Thomas Sullivan lived every father's nightmare. His daughter said some things which caused her mother to take her to a crisis care centre where she was examined by a medical practitioner. That medical practitioner allegedly performed those duties negligently and concluded, wrongly, that Mr. Sullivan had abused his daughter. The consequences were devastating. The breakdown of his marriage, adverse orders in the family court, with consequential impacts on his relationship with his daughter. There were two other cases with remarkably similar facts. All three appeals were heard in the High Court together. The threshold question was whether there was a duty of care at all. The plaintiffs argued that it was reasonably foreseeable that if the doctors did not perform the assessments properly, they would cause harm to the child's other parent, if that parent became a suspect. Nobody really doubted that this was true. The question was whether this reasonable foreseeability was enough to form a duty of care in negligence. There were two barriers to such a finding. First, it had become settled law in Australia that there had to be sufficient proximity between a plaintiff and a defendant for a duty of care to exist. However, this term really had not clarified the situation much. The court said the formula is not proximity. Notwithstanding the centrality of that concept for more than a century in this area of discourse, and despite some later decisions in this court which emphasised that centrality, it gives little practical guidance in determining whether a duty of care exists in cases that are not analogous to cases in which a duty has been established. Instead, they said, when examining a novel type of alleged duty of care, a court should simply look at all the factors in favour of a duty and all the factors against and decide whether the duty should exist. One of those factors is that a person cannot logically owe two separate and conflicting duties of care at the same time. In this case, the medical practitioner's first and highest duty was to the welfare of the child, and it would not be consistent with this duty to hold that they also had duties to those who might be suspected of offences against those children. As a result, the court found that there was no duty of care and therefore no negligence by the medical practitioners.